Good afternoon and welcome to this afternoon's webinar, Privacy in Practice, 1 year on. My name is David Griffiths. I'm Joint Managing Director of CompliSpace. Before we get going, a little housekeeping. This afternoon's webinar will go for just under an hour, I'd suggest, being a Friday afternoon. We're recording the webinar and we'll provide each of you with a link to it early next week should you wish to forward it to any colleagues who've missed out this afternoon. It'll also be available for viewing on schoolgovernance.net.au, that is www.schoolgovernance.net.au. You can see the webinar console allows you to ask questions. Please feel free to add any questions you may have as we go. In the interest of time though, I won't try to answer these during the course of the webinar, but I will distribute a written response to the questions asked early next week so that everyone can review what your fellow participants are asking around privacy. Now, many of you will be familiar with CompliSpace and what we do. However, for those who are not, we are a leading provider to non-government schools of cost-effective online governance, risk compliance and policy management solutions. Our schools are in every state and territory in Australia, and we don't just provide our services to non-government schools. We also cross those services over to organisations in other sectors and industries, including the financial services industry, to hotels, to ASX listed companies, and to the not-for-profit industry generally. I'll just make a quick point now that it's interesting to note that across our fairly diverse client base, it is clear to us that 1 year on since the introduction of the new privacy laws, and the non-government school sector remains to us certainly the one sector that we see as facing the biggest challenges with respect to privacy compliance generally. So why is privacy such a hot topic, and why is it still such a hot topic? Well, for starters, in case you're not aware, it is actually right now Privacy Week, with its theme Practicing Privacy Every Day, or hashtag Privacy Every Day for those that want to see that trending. It is over 1 year since the introduction of the new privacy laws in Australia, and indeed the real thing that we see since that introduction is that we are being made aware of privacy issues every single day. Think political posturing about metadata, think press about recent developments in privacy enforcement, forcing ISPs to hand over personal information of customers who have pirated film content. Think identity theft, think fraud, viral social media exposés about individuals, think child protection issues. The reality is that privacy has indeed become an everyday issue, and we're constantly being presented with surveys around this and survey results around this. And I picked up one this morning only around, it was an Intel security survey that was presented. And interestingly, it's clear that from this survey that the protection of personal information is something that members of the public, members of our school communities take incredibly seriously. What I find interesting about the statistics on the screen in front of you here are that if we ignore the first dot point and go to the rest of them, we can see that 80% of individuals express high concern about privacy of their personal information. A quarter of individuals believe organisations are quick to fix instances of misuse of personal information, and half of the respondents believe organisations with privacy policies in place are more trustworthy. Yet, despite the fact that individuals clearly see privacy as a critical issue, over 90% could not name the Privacy Act. What does that tell us? I think that really tells us that individuals, customers, consumers, members of school communities take privacy incredibly seriously, but they haven't yet grasped the legal compliance framework, or they are still grasping the legal compliance framework that is in place around this. So whilst we're 1 year on since these laws were introduced, organisations and individuals are still coming to grips with them. And that final dot point on this slide shows that statistic of just over half of the respondents to the Office of the Information Commissioner's assessment of 20 large Australian and international companies, just over half of them had privacy policies that did not meet one or more of the content requirements in the Australian Privacy Principle 1 around transparency of information. So we take this stuff seriously, but organisations are still struggling to come to grips with it. So why is this so critical for non-government schools? Well, first things first, the laws have been enforced now for over a year, or the amendment to the privacy laws have been enforced now for over a year. It is a comply or die environment out there, and there is indeed nowhere left to hide. So if we take an example of a school, this is just to emphasise some of the complexity faced by schools. It's not if a privacy breach will occur, but when a privacy breach will occur. Let's think about a school, your average size K-12 school, 1,500 students. It probably has up to 3,000 parents. It may have 3,000 prospective parents, 200 staff, 10,000 alumni. Very quickly, a school of that size can be holding personal information for up to, say, 15,000 individuals. Now, if your school community, as is a typical school community, includes IT professionals, business execs, lawyers, accountants, and probably more commonly tech-savvy individuals, then you can simply assume that it's genuinely not if a privacy issue or breach will arise, but when a privacy issue or breach will arise. You are absolutely guaranteed that fact. Whilst this afternoon's webinar will provide a bit of a recap on the privacy laws and in particular a bit of an exploration of the laws in application 1 year down the track, there is some background information available to those who have a greater interest in the area and need to seek more detailed information. In particular, we have issued a briefing paper for non-government schools that's available on the School Governance website. We also produced a webinar just over a year ago as the new laws were rolling in that provides a much more detailed overview of the Australian privacy principles than I have time to provide for you this afternoon. As well as that, we've, over the last 6 weeks or so, been publishing some blogs on various practical topics and issues that have arisen around privacy. So I would urge anyone who is interested to access these resources, and they provide a good exploration of privacy compliance for non-government schools. So why stay longer than the first 10 minutes of this seminar? Well, we're going to cover a few things here. We're going to do a recap of privacy a year later. Most importantly, we're going to talk about some of the bigger issues that face non-government schools in relation to privacy. And I'll do that by reference to some of the cases that have been handed down or the decisions that have been handed down by the Privacy Commissioner. I'll do it in the context of the consequences for those involved and provide some everyday examples that relate to non-government schools. I'll finish the webinar by providing some practical tips for non-government schools. Just before we get going, when we last did our webinar, we outlined a number of myths and we sought to bust those myths. I think it's important that we revisit these just over 12 months later. So here they are, and 12 months later, really what we've seen is the addition of a new myth and the deletion of the transition period myth. But here they are. Myth number 1 was the use of pro forma privacy manuals. Number 2, the Privacy Commissioner is a toothless regulator. Number 3 or 4 in this case, all I need is a privacy policy. Myth number 5, privacy compliance is just box ticking. And number 6, it's the school's obligation, not mine. Let's have a quick chat about some of these. Number 1, now a school is required to implement internal practices, procedures and systems in order to comply with the privacy laws. Taking a pro forma privacy manual, putting your school's logo on the cover, then storing it on the X drive is just not privacy compliance. It probably, if anything, increases your school's liability, and it's incredibly dangerous to do. We have seen that done on many occasions with schools, and it is something that it is a myth that needs to be broken quickly. Number 2, the Privacy Commissioner is a toothless regulator. Look, the Privacy Commissioner has an array of powers and is using them. We've seen Optus issued with an enforceable undertaking. We've seen Virgin fined. We've seen various other organisations dragged over hot coals for their conduct over the last 12 months. Remember, the Privacy Commissioner has the power to issue penalties of up to $2 million for an organisation and almost $400,000 for an individual. The Privacy Commissioner has a big stick, and he is prepared to use that big stick in enforcing these laws. It's extremely important for schools to be very aware of that and to understand that at the other end of this, it might not be the fine or the penalty or the compensation order that they're concerned about. There is a huge reputational risk associated with a privacy breach. Myth number 3, all I need is a privacy policy. Now, the most common myth that we see embraced by the non-government school sector is this one. A privacy policy is just the tip of the iceberg. It simply summarises some key information on the internal practices, procedures and systems that your school has implemented to ensure that you comply with the 13 Australian privacy principles. If you haven't actually implemented those practices, procedures and systems, it would of course be misleading and deceptive to publish such a policy. Yet this is something that we see as most common across the non-government school sector in Australia, simply thinking that privacy policy is privacy compliance. Myth number 4, privacy compliance is just box ticking. Look, I can't put it any other way to you than to say privacy must not be confined to the realm of the business manager or the registrar or the admin part of your school. It has to be practiced from that office all the way to the coalface of the school gate, the classroom, wherever it may be. Privacy must permeate every single level and functional area of your school. It is not simply an admin issue. Myth number 5, it's the school's obligation, not mine. Look, the message here, when it goes wrong, there are consequences for everyone, could not be more correct. I think one of the big things that we see with schools is that a simple oversight by a staff member might have really serious consequences. And we've seen this a number of times, both publicly and across schools that seek advice from us from time to time, where it might be something as simple as sending a group email or accidentally auto-addressing an email that extends information beyond the boundaries of your particular school. These are really simple oversights by staff members, but they can have really serious consequences for the people whose information has been disclosed. They can have extremely serious consequences for the staff member who has committed that oversight. Think about employment laws, think about serious misconduct. Privacy overlaps in great detail with HR and IR laws. Think about social media and the comments made there and other policy management areas. So I can't emphasise that enough, that individual employees share the responsibility and have personal obligations around privacy, not just under the privacy laws, but also in other areas of legal compliance as well. Okay, now to recap the privacy laws. To do this, we're going to provide an overview of the 13 Australian privacy principles, but the way in which I'll provide this overview is by reference to this diagram that's in front of you that covers the privacy life cycle. Now, just remember, we do provide a much more detailed summary of the 13 APPs in our white paper and webinar, which are available on the schoolgovernance.net.au website. This privacy life cycle is broken into 5 parts, and I'm going to start by going through each of those parts and just outlining at a high level what they cover. The first one, part 1, Part 1 covers privacy by design and the requirement that schools have in place open and transparent management of personal information, and APP2, which covers the entitlement to anonymity or pseudonymity for persons dealing with your school. Now, it's a central feature of the amendments to the Privacy Act that schools have to have in place procedures, practices, and indeed systems that are integrated within your organisational governance framework that ensure compliance with the 13 APPs. Part of that is the requirement to also manage privacy in inquiries and complaints, and this whole requirement is referred to as privacy by design. It is an area of challenge for schools to understand what that means, and I will touch on that shortly, but in essence what it requires schools to have in place is a detailed, documented privacy program that outlines the whys about why we do privacy compliance. It outlines what we have to do as a school in relation to privacy. It outlines how we do it, who is responsible for it, and when we are required to capture information and fulfill our privacy obligations and indeed report on privacy on an ongoing basis. The new laws also require the school to publish a privacy policy that spells out certain key information around the collection, the use, the storage, the management, the access to personal information as managed by the school. Part 2 of the life cycle covers the collection and notification requirements. Basically a starting point for a school is to understand what personal information is. And really what it is information about an identified individual or an individual who is reasonably identifiable from that information. Schools also have to understand what sensitive personal information is and what health information is, because the type of information that the school captures or collects and holds determines the nature of the protections under the Privacy Act and other legislation. Bear in mind that there may be some overlap with respect to certain information collected by schools. In particular, I'd cite health legislation for sensitive medical information that a school might collect. So APP3 covers the collection of solicited information, that is information you ask for as a school. And in essence, a school can only collect personal information that is reasonably necessary or directly related to one or more of its functions or activities. For sensitive information that it might collect, it requires consent, subject to exceptions, of course. The issues that a school needs to consider around the collection of information are things like, how is it collected? Is it collected via forms, the most common way of collecting personal information? Is it collected face to face? Does someone hand over a post-it note with personal information on it? Bear in mind, simply telling someone something may not be seen as the collection of a record of information, because a record is required to be in electronic or documentary form or in an audible or in video format. So it's extremely important that there is some record. It may be through surveillance that the school's collecting information. The school also has to consider whether or not it's asked for the information, so it's solicited, or indeed it is unsolicited information. And in the case of the latter, of unsolicited information, APP4 sets out the requirements for dealing with that type of information. APP5 sets out the notification requirements for at the collection point and thereafter in relation to personal information. And what it really points a school to is the need to have both a privacy policy in place that is appropriately drafted for the school's needs and its practices, and also the use of collection notices for individuals so that they are adequately notified around the school's practices with respect to their personal information. Part 3 deals with information use and disclosure, and it covers 4 different APPs, and they are APP 6 on the use and disclosure of info, APP 7 direct marketing, APP 8 on cross-border disclosure of personal information, and APP 9 on the adoption of government-related identifiers. In a nutshell, a school may only deal with, use or disclose information if it's for the primary purpose for which it was collected or for a secondary purpose with consent, subject to exceptions, of course. Now, the best place to look for the definition of what is considered to be the primary purpose of collection invariably is to go back to a school's privacy policy to see what it determines are the functions and activities that it undertakes, and therefore the primary purposes of collection. Now, the APPs also introduce far stricter rules on the sending of personal information overseas and the use of information in direct marketing. And the sending of personal information overseas is a particular area that we see schools struggling with their obligations under APP 8. We see many schools disclose in their privacy policies that they don't actually send information overseas, when the vast majority of schools actually do so. And I will come to that a little later. Part 4 covers quality and security of personal information. Now, aside from schools having to have practices, procedures and systems in place to ensure that personal information is accurate, up to date and complete, and what does this require? It requires audits of information and storage systems, training and a simple means for individuals to review and update the info. Another big issue is the security of personal information. So a school has to take active steps to protect personal information from misuse, interference, loss, unauthorised access, modification or disclosure. There are many challenges when it comes to the security of personal information. The challenges will differ depending on the way in which the information is collected, the way in which it is stored, and we see a variety of those methods of storage in the schools that we deal with and that we speak to. They may be storage of personal information in filing cabinets, on staff members' PCs, in student information management systems or web-based learning management systems and other databases. Now, managing the data security breaches is also a huge challenge, and the Office of the Australian Information Commissioner continues to produce more content and guidance around that for schools to consider. There are also related policies that are not necessarily privacy policies, but do relate to and help to control risks around the security of data. These include confidentiality policies, which extend to confidentiality clauses in employment agreements. They include destruction of confidential waste policies. They include bring your own device policies and indeed password protection protocols that are in place within schools. It is a huge issue, and it's an ongoing issue for schools. Part 5 covers access to and correction of personal information. It includes APP 12 and APP 13. In very simple terms, schools have to have very clear procedures on managing access to and correction of personal information, because an individual whose information a school holds is entitled to access their information and to insist upon correction of their information. Of course, there are exceptions to that entitlement, but that's the general principle. So what do schools have to do around this? Look, what it really requires is very good file management and records management. It requires good database and workflow management, and it requires a clear policy and strong, robust staff training in the area. It is a classic area of reputational risk for schools, and we see it in many ways through schools. An example is the fundraising letter that is sent to the deceased parent of the current student, or information that goes off to a former student's parent or something like that. It's not uncommon with problems with database management, and can be embarrassing for a school. So 1 year on, what are some of the bigger issues that we see schools facing? The first one is around collection and notification. And in days gone by, I think it wasn't uncommon for a teacher to have a conversation at the school gate with a parent about a student, and it may have been that conversation may have been overheard by another student or indeed another parent. Now, this conversation may have included discussion of particularly sensitive personal information. It may have been a medical information, or it may have been information about the parent's personal circumstances. A similar set of circumstances occurred in the Virgin case that's mentioned there, but this related to a disabled passenger's medical condition being discussed in the departure lounge within earshot of other passengers by the Virgin contractor. Look, in that case, the matter went before the Privacy Commissioner, who issued a determination which was that this was a breach of the predecessor to the APPs, being the National Privacy Principles, as it was a failure by Virgin or its contractor to meet both its collection and its disclosure obligations. I can't emphasise it enough. This, more than any other example, emphasises the importance of training for staff, that they are trained, and all staff are trained on their privacy obligations. And in that way, you can take privacy compliance from outside the administration area of the school, i.e. the business manager's office, all the way to the coalface of the classroom and the school gate. The key mantra, as I put on there, is if it's personal, let's keep it that way. So we have to be very, very particular about how we deal with personal information. And again, just to emphasise it, many of the breaches that we see occurring, both in the press and outside the press, are invariably due to human error, to the inadvertent and accidental auto address function on Outlook to a group email using the CC function on Outlook rather than BCing the addressees. It may be with the best of intentions that these breaches occur, but nonetheless they do occur, and it's extremely important that all members of staff understand what their obligations are in that regard. Another area is around use and disclosure. This is another huge issue that we see constantly coming up, and it's obviously covered by the Australian Privacy Principle 6 on dealing with and using and disclosing personal information. On the topic of this, the case regarding the Synod of the Diocese of Brisbane was an interesting one, because in that case the Privacy Commissioner held that there'd been a failure in relation to the proper use and disclosure of sensitive information of an individual. Now, without going too deeply into the facts, it did concern the details of a complaint by a former pupil of a particular school within that diocese. And that complaint included certain sensitive information. That sensitive information was provided to council members of the particular school within the diocese, and the individual concerned subsequently made a further complaint that his identification information had been provided in the info packs to council, and he claimed and maintained that they didn't need to know his identity to deal with the issue that they were asked to deal with. And he further complained that the information packs may have been given to the children of council members for delivery to those council members. Now, one can understand and foresee how that would happen. It's simply a practical, logistical issue, probably inadvertently, a mistake inadvertently made by a staff member with the best of intentions. Can't emphasise that enough. However, in this case, the Privacy Commissioner found that the complainant's identity was not necessary for the council's task that they were asked to consider. Further, the Privacy Commissioner found that the diocese had failed to take reasonable steps to protect the information that was sent through to the council members from unauthorised disclosure by delivering the info packs via the children of those members. A very simple mistake and a simple issue, but nonetheless a fairly serious finding by the Privacy Commissioner. Now, in this case, the complainant was awarded $7,500 in damages, and the damages included damages for pain and suffering and humiliation. So a fairly serious outcome. Now, whilst you might look at that, the quantum of the damages in that case and relate them back to your school and consider that they're not overly significant, you must consider the reputational risk and reputational damage that arises from such a finding to your school and indeed in this case to the diocese. I might just add that we did produce a blog in School Governance on this particular case, and the diocese did put, and the school did put, a lot of systems and checks and measures in place during the period whilst this complaint was being heard, and prior to that period indeed, to ensure that this would not happen again. So it was commended on that point. But it is something that every school, I'm sure, can relate to, being in that circumstance. A further quandary arises for schools in the management of personal information of alumni, and it's, in our experience, it's not uncommon for a school to manage the alumni database on behalf of the alumni body and then to share it with the alumni association from time to time. It often depends on the size of the school and the alumni body as to how separate those two, the alumni body is from the school, but we're indeed seeing a lot of shared resource there. Now, I just flag at this point, without making any or casting any opinion on that sort of circumstance, I just want to flag a really serious issue that arises. And this set of circumstances can raise a number of problems, not the least of which is the fact that a number of the state-based association incorporation acts allow an alumni member of that state-based association to request a full list of member contact details from the alumni body. Indeed, that is an entitlement of a member of a state-based incorporated association under many of the state-based laws. Now, at first glance, that state law entitlement may result in a breach by a school in its use and disclosure obligations. So a school and its alumni body must both very carefully consider how personal information is handled, the relevant notifications it provides to alumni, and the consents and security of access issues. I know that for many schools, the consent to become a member of the alumni body may be given at enrolment. It may indeed be signed off on valedictory day, last day of school, on exit and finishing from the school. The reality is these are serious issues that need to be considered by both. A further serious issue is database management generally, because if the school is managing the database and the alumni body is asked to change or correct information, there obviously need to be tight protocols as between school and alumni bodies for the maintenance of that information. Another issue that I mentioned a little earlier that's causing big issues for schools is that of cross-border disclosure of personal information. Now, APP 8 covers the cross-border disclosure of personal information, and what it actually says is that where a school discloses that information to an overseas recipient, now by overseas recipient think cloud service provider in many cases, then it must take reasonable steps to ensure that the overseas recipient does not breach the APPs. Okay? A school will be legally accountable if the recipient mishandles the information unless the school has the individual's consent to the overseas disclosure or the school itself satisfies itself that the overseas recipient is subject to the laws of a country or a binding scheme that it believes to be substantially similar to the APPs, and the individual can access those that binding scheme or those laws. That's a very long-winded way to say that schools are responsible for that information in the main part. Now, we see many schools who continue to deny that they disclose information overseas. And one of the easiest ways to see that is simply to go onto a public website to have a look at their privacy policy that most schools have on their public website, and to simply go through that privacy policy and see what their statement is around the position with respect to cross-border disclosure. Now let's look at a couple of scenarios. Let's take an email written about a student by the school to a parent who is overseas. That email constitutes a record for the purposes of the Privacy Act. If that email includes personal information, then that is a record of personal information, and that is a cross-border disclosure. That email is being sent to a foreign jurisdiction. So that in itself is a cross-border disclosure of personal information. Take the posting of an image on Facebook. Take the posting of an image on Twitter. Now, the image might be of the school's swimming carnival. Twitter and Facebook, both hosted in overseas jurisdictions, in foreign jurisdictions. Again, a cross-border disclosure. Let's look more deeply at than those sorts of examples. Take the use of a learning management system that may be hosted in a foreign jurisdiction, or a student information system that may be hosted in a foreign jurisdiction. Again, cross-border disclosure. So most schools, in our experience, disclose personal information overseas. So what they should do about that is to address it properly in their privacy policies. If they don't address it in their privacy policies, obtain the relevant consents if they wish to go down that pathway. If they don't address it properly, they face the risk of serious reputational damage that comes with the possible breach. I've mentioned there the OPSM case where OPSM lost a $33.5 million contract with Medibank because it breached its privacy obligations in its supply contract with Medibank. In that case, OPSM supplied services to the Australian Defence Forces and to Australian Defence Force personnel. Now, it stored its information outside the Australian jurisdiction, in a foreign jurisdiction, contrary to the express contract provision requiring it to store all information in Australia. That is a fairly significant revenue loss there when you look at the size of that contract. What could be deemed to be a relatively simple error by OPSM, but with very serious ramifications. Look, the message to schools is a simple one. Ensure your personal information audit covers all cloud providers and all practices within the schools. I've mentioned some examples of those practices, and you should ensure that you are aware of all of the ways in which you use, store and disclose information. Then ensure your privacy policy reflects the reality, not the hope. Security of personal information. This is and will remain one of the biggest issues faced by schools. In fact, it's one of the biggest issues, as you can see from some of the names there, faced by all organisations. Look, I mentioned there the Optus and Cupid Media cases around the compromising of technology. In both of those cases, thousands and thousands of records of personal information was compromised due to databases being accessed through the shell shock bug that has been around for some time. In the case of Optus, the Privacy Commissioner actually accepted the first enforceable undertaking under the new laws, and in that case it was a detailed enforceable undertaking from Optus. Optus's breach had affected thousands and thousands and thousands of its customers, and it did take some time to rectify the breach. And in this case, as a result of its failure to take the relevant steps to safeguard the personal information it held, an enforceable undertaking was put in place. Cupid Media was a a dating site, so to speak, and again, the information of, in this case, hundreds of thousands of Australians was made available and disclosed due to the shell shock bug and due to essentially a database breach. Look, in both of those cases, both of the companies suffered very serious reputational damage, and that's probably one of the most important things. They also forced both of those companies to commit huge resources to rectify the error, and that would have an enormous financial ramification for each of the companies. This is indeed a real issue for schools who increasingly use web-based systems to store personal information and in many cases to share information. We see it not being uncommon for secondary schools in particular who might share resources with other schools who may be a related entity or not a related entity of the schools. They may have year 11 and 12 classes shared for local schools, and in that case they may share the personal information of students via electronic systems. It's extremely important to consider the different scenarios that might arise, and critically the different security protocols that are in place so that the schools are able to maintain security with respect to their data on their databases. Now, another failure around the security of personal information was in relation to the Pound Road Medical Centre case. In that case, there were boxes of unsecured medical records, I think for some 960 or so different former patients of this particular medical centre. These were found on a site that was managed by the medical centre, and they were found to be unsecured. Someone had broken into the storage out the back of the medical centre. In that case, the medical centre was found to have failed to take reasonable steps to ensure the security of the personal information and to have a protocol in place to destroy information over time. The information was some years old and was for former patients. But nonetheless, that provides a very pertinent message to schools. Schools indeed do store information in a similar way. In many cases, they obviously store a lot of hard copy records, and it highlights the dangers of failing to properly secure those hard copy records and of failing to have a policy in place around, in some cases, destruction of records, or in most cases, the virtual storage of information on an ongoing basis. We see that a lot with schools who are migrating hard copy records to a virtual storage environment, and we're often asked that question around how long they should go about keeping their information as a sidebar issue on this. And we recently released a blog on the point around record keeping in schools. It is a very sensitive point, this one, especially in light of royal commissions and the like, where schools really in this day and age, if the information that they are keeping or seeking to keep, whether it's in hard copy or soft copy, has any sensitivity, then they really should migrate it to a virtual environment, save it securely in the cloud on an ongoing basis. Another very big issue that we see schools struggling with on a day-to-day basis is this concept of privacy by design. And what does that cover? Let's remember or recap that. It covers the practices, policies and systems that a school has to have in place, integrated with that school's organisational governance framework. Excuse me. That is a real challenge for schools to have that in place. And they're really struggling taking that out of the back office and into the front office, if you like. And as I've said, they're taking it out of the realm of the business manager and the registrar and the admin department through to the front gate of the school and the classroom. So how do schools do it? And look, that is the big challenge. But here are some practical points to make about how to make privacy by design come to life. schools have to start with a documented privacy program. They have to have someone who's responsible for privacy. So appointing a privacy officer is critical. Now that won't be a full-time role, clearly. That invariably will be the role that is shared by someone as part of their responsibility. We often see that falling into the realm of the business manager, and to all those business managers who are participating, I apologise for saying that, or a staff member that sits within the admin department of a school. It requires the integration with existing systems, and not just, I guess integration starts with consideration. You have to consider what systems you currently have in place. And I've put there LMS for learning management systems. What do you use? What HR information systems do you use? Where do you record your student data in the student information systems? Now you might be doing all of that manually. You might be doing it all in Excel. We're increasingly seeing schools using one or other of the various systems that are out there and are available. And one of the key aspects of privacy by design is to consider how privacy integrates within those systems. All of those systems that we see have different checks and measures built into them to help cover off your privacy obligations. So it's a matter of sitting back and designing how you are going to do this as a matter of workflow to ensure that it all works and that you are compliant. Complaint handling program is really important for privacy. Obviously, under your privacy obligations, one of your core obligations is to be able to deal with privacy inquiries and complaints. And that is just one of the types of complaints that one might receive under a complaint handling program. It is absolutely critical that all staff are trained. And I've mentioned that a number of times. Privacy cannot work in a vacuum. It does not sit within the business manager's office. It has to be at the front gate, it has to be in the classroom, it has to be on the sporting field. It has to permeate all levels of a school environment to come to life. And the final big jigsaw puzzle piece that you need is this monitoring and improvement loop. It's one thing to put these things in place, but how are you making sure that it's actually working, that you're gaining assurance that people are doing what they're meant to do, that you're monitoring that, and that you're improving it where you identify systemic issues that might come up. What you can see from all of this is privacy is not simply just a matter of putting a privacy policy on your public website. It is much more. So 1 year on, what are some of the big risks that we see for schools? Well, the first one here is the obvious one, not understanding your privacy risks. We said this over a year ago, and it remains really the top risk. It's simple, obvious, and certainly not uncommon. The next one, failing to complete a personal information audit. Now that might not seem as that obvious, but really it is only by doing a personal information audit that a school can then work out what info it holds, how it holds or stores that info, how it discloses and uses the information, etc., etc., etc. Many of the failures that we see are in fact through individuals inadvertently breaching privacy obligations by doing what they think is the right thing. And I've already mentioned the examples of individuals accidentally sending group emails, all done with the best of intentions, but of course school not having considered how information flows in and out of its organisation, hasn't put systems in place and training in place to cover these sorts of scenarios. So that personal information audit is critical. The next one, failing to adequately secure personal information. Absolutely obvious, but it is and will continue to be one of the biggest privacy issues that schools face. More and more schools are going from manual management environments to more automated environments. More and more schools are using web-based resources to manage workflow and information. There is more and more information flowing in and out of schools every day. So it's absolutely critical that you are able to consider all of the security in place around the different ways that you store the information. Not training staff, incredibly obvious. Again, one that we see is is a huge area of risk for schools. Final time of emphasising this: privacy cannot be limited to the business manager and registrar's office. Staff have to be trained at all levels. The final one is not adopting privacy by design. In a way, that covers all of the above. But as I've mentioned, privacy by design can be a difficult concept to implement. Really what it comes down to is that privacy doesn't work in a vacuum. It has to be integrated as part of a school's other management infrastructure. It's other GRC, or governance, risk and compliance infrastructure. So what are some of the steps to privacy compliance for a school? Well, just over 12 months ago, we did a blog on this, and we came out with these 10 steps. And funnily enough, some 12 months later, we really go back and review these steps and see that they're still incredibly relevant for schools that we see and speak to. If you're interested in reading that blog, it is on the schoolgovernance.net.au website, so do go and have a look. But running through them quickly, the appointment of a privacy officer, already mentioned that as a big factor. Fast tracking the privacy knowledge. So what does that require? That requires training. It requires a board paper being put to the board. An example of that is the briefing paper that we have available on the school governance website, which was actually designed as a briefing paper for board members and for executives of schools. Documenting your privacy program. It's not just a policy sitting on a website, it's a fully documented program covering the who's, what, where's, the whys and the hows and the whens of privacy compliance. Conducting that personal information audit, huge issue, just mentioned it. Creating that initial draft of the privacy policy, well, look, in truth, that's one that should be amended there. We're way past that. Having a privacy policy that actually reflects reality in your school, not what you perceive as reality. Okay? Having a privacy policy that reflects how you deal with cross-border disclosure and so forth. Closing the gaps of all of the above, still a huge issue. Just taking a deep breath, monitoring and improving and tightening up your progress. The next one, reviewing complaint handling procedures. Look, we're finding this is a bigger driver for schools across the whole school now as they try to improve service and differentiate from each other. Staff training, huge step, emphasised it already. Publishing the privacy policy. Now, if you haven't published your privacy policy yet on your public website, then do it immediately. It's an absolutely critical step in this. You have to do it by law. You have to have the privacy policy in place. That is the first place people look if they have an issue with your school around privacy. And the final one is having a monitoring and review loop built in, which I've already mentioned. Okay, just unashamedly a little plug, if I may, around CompliSpace's expertise in this area. This is, as we draw this webinar to a close, as many of you will be aware, CompliSpace's online governance services deliver an integrated policy management and assurance management to non-government schools throughout Australia. And our privacy module as part of those services includes a range of different resources that are customised for each school and kept up to date with changes in law. So that includes the broader privacy program, privacy policies, a personal information audit template. And as I've mentioned throughout this webinar, the importance of that process, that provides a roadmap for you to undertake that personal information audit within your school. It's not a small task, but with the roadmap at hand, it can make the task a lot easier and simpler. Provides consents and the notifications and letters, and finally it provides the training modules and the content that goes with that for implementing your privacy program across the whole school. Really importantly, privacy doesn't sit in a vacuum, so our program and our privacy module forms part of our broader suite of modules, and it indeed integrates with our risk module and our compliance module and complaints modules and so forth. And the corresponding related policies that go with that, covering both HR, and some of those policies are mentioned on this slide, all the way over to WHS or OS&H if you're in the West, and OH&S if you're in the South. It's extremely important that privacy is integrated with the other functional areas and disciplines within your school, from HR, WHS, student duty of care, risk, compliance and complaints. Again, remember, it doesn't work in a vacuum. So our services are specifically designed to ensure a school-wide proper privacy compliance can be achieved. Finishing off now, I'd like to thank you all for your attendance on this Friday afternoon for this privacy webinar. I hope that it has been helpful. I hope that it has been informative for you. Should you wish to know more about our services or just to discuss privacy in more general terms, then please feel free to make contact with us. We'd be only too happy to help. Thank you very much.